The Employment Non-Discrimination Act, also known as ENDA, recently lost the backing of the ACLU and two major LGBT equality groups. Now these groups, again Lesbian Advocates and Defenders and the National Center for Lesbian Rights, have decided to stop urging President Obama to sign the act due to a specific provision. Now you're probably asking why several prominent civil rights groups are now refusing to support a non-discrimination act. What kind of provision, right? Well, their refusal to support it comes back to the recent Hobby Lobby ruling. Now wait a minute, what does Hobby Lobby and contraception have to do with LGBT discrimination or LGBT discrimination in the workplace? I'll explain. ENDA, as it's currently written, has an exception for religious groups. The ACLU, GLAD, and other groups point out how this exemption essentially opens the door for corporations with closely held religious beliefs, yes, we're hearing about that again, to be able to work around the discrimination laws in ENDA. In a joint statement, these groups wrote, quote, if ENDA were to pass and be signed into law with this provision, the most important federal law for the LGBT community in American history would leave too many jobs and too many LGBT workers without protection. Moreover, it will actually might lessen non-discrimination protections now provided for LGBT people by Title VII of the Civil Rights Act of 1964. Very likely would generate confusion rather than clarity in federal law. So these groups will not support ENDA unless that religious exception is written out. And look, I agree. With the Hobby Lobby ruling that could pave the way for employers and corporations to be exempt from certain government mandates because of closely held religious beliefs, one of which most certainly involves opposition to gay lifestyles, this provision could definitely lead to employers using those beliefs to sidestep ENDA. For me, this is another example of the Hobby Lobby ruling stepping into that minefield that Ruth Bader Ginsburg warned about in her dissent. Speaking of the dissent, Ginsburg wrote, quote, suppose an employer's sincerely held religious belief is offended by health coverage of vaccines or paying for the minimum wage or according women equal pay for substantially similar work. Now, I want to go to the panel here and ask you guys what you think about this whole thing. And let's start with you, Becca.
Okay, so there's a couple of conversations that have been going around about this that I think really need to be addressed to explain why these groups have pulled out. Because on the surface, the Human Rights Campaign chose to still endorse ENDA in its current form with the religious exemption, arguing that backing off of it sent the wrong message now. And in response to that, several people have been saying, well, what if the Civil Rights Act had come with a religious exemption? I want to make sure people are aware that actually Title VII did. But, and this is the really important difference, the Title VII religious exemption said it was for work that directly related to the religious mission of a religious organization. The religious exemptions involved currently in ENDA are much more troubling. Some of them do have to do with that work of the education, including any work directly in a church, in a school, in a mission. That's problematic to me, but much more troubling is that one of the provisions would allow for complete exemption for classes of jobs belonging to religious employers, which is to say that a hospital owned by a religious organization could choose to say, none of our nurses can disagree with these religious tenets of ours. That's a much more sweeping, much more troubling religious exemption. And so I think given the recent willingness of our high courts to endorse really troubling directions with this, I think withdrawing support with this current religious exemption was the only sensible thing to do, really. If there was a more restricted religious exemption, that seems perhaps more responsible. It's still something that I personally would rather see just not there, but it's the broadness of this particular religious exemption. It's not right to say the Civil Rights Act didn't have one, but it's also not right to say that the two are the same. This one's much broader.
Right, and that's the problem with this whole thing is how broad it's gotten. And I Ruth Bader Ginsburg, man, she saw this whole thing coming, and once again, it's starting to blow up in our face. And here to disagree with us is Sean.
Well, I mean, I don't disagree completely. I'm just pointing out that it's not broadened yet. Like they're worried that this exemption, that the Hobby Lobby case could be used as precedent to exploit this exemption, but that hasn't happened yet. Like the bill has to pass, and then it has to be tested at the courts and all that. But like the overall problem in this, and if I'm the bad guy for saying this, then whatever, is it's the parts of it's where the protections of minority groups runs up against the freedom of association, the concept of freedom of association, because we don't want anybody to be discriminated against, and there's no like I'm not gonna be that guy who's like we never should have passed the Civil Rights Act, but one of the big pieces of it that I think was totally needed at the time and probably definitely is still needed today in a lot of cases was the idea that you were preventing business owners from discriminating based on their own judgment. Now, discrimination is freedom of association, like whether we like it or not. Like you should, in theory, be able to decide who you want around you, whether that be in an employment setting or all that. So all these religious exemptions and all this other stuff, it's just like another way to get back towards that freedom of association, which I don't even think anybody on this panel wants, but that's really like the crux of it. It's not really a religious thing, in my opinion. It's whether or not employers can fire people because they don't like them or like their behavior, and like that's the real question in this.
Well, I don't really agree with that. I think it's really based on. I think a lot of it is based on religion and using that religious justification in order to impose their values on other people.
No,
Especially,
I understand that. I'm just saying, like, the religious exemption isn't like I don't like the religious exemption is weird to me because it's like, oh, if I believe in God and that makes me hate gay people, I should be able to fire them. But what if you're like an atheist who just hates gay people? Like you can't fire them. Like your beliefs would be as sincere. That's why I don't like. That's why like it when you cut through like the religious exemption, the non-religious exemption, or whatever. It's really about whether you have that right to discriminate or that right to freedom of association. So it's really like when you cut through all the bullshit, what this case is what this case is about. And as far as the groups like not supporting the law, I say support it. Like you can try and get that exemption removed or shrunk, but like get it passed, and then worry about the consequences later.
I kind of like the example that you pointed out here between the atheist and the Christian, and it just really kind of shows, I think, whose closely held religious beliefs the High Court seems to agree most with, and it always just happens to be Christianity. Interesting. Becca, did you have something to say?
Yeah, just a quick. Partly the group's decision to withdraw support is symbolic, but that's because we weren't looking at any real chance of getting it passed this year anyway. We are looking at probably a 2015 ruling, June 2015 ruling, that could make a huge difference. Not on ENDA, but as long as Boehner is the one deciding what's coming to the floor, and we're not looking at getting this passed this year anyway. And so the withdrawal of support is more symbolic. It's to say this is not acceptable. We know that we were probably going to be stalled out right now, but we would have kept pushing for it, except these things are starting to make some really big problems for us. So if we're going to push it through, we're going to push it through the way that we want it.
Right, and in reality too, trying to, we've heard about them trying to push President Obama to sign an executive order, also pushing this, and politically that doesn't seem like it's going to happen, because we know President Obama is essentially not going to do anything like that. I mean, come on. I don't have a lot of faith in President Obama doing a whole lot, especially if Republicans disagree with him. Because Fox News is going to explode, right? Their heads are going to melt if he makes any sort of executive decision. They're going to cry tyranny, which they already do anyway. I mean, that's kind of what Republicans and Fox News do. So, as far as the groups,
it depends. It depends on what the context of the executive order is. Like if you're saying, like executive orders to clarify laws, like that's the president's job. Like this is how I'm going to enforce it. Like laws
an executive order to put ENDA into effect.
Yeah, but that's what I'm saying. Like you really can't have him sign an executive order because the Congress won't pass the law. Like that's subverting the legislature. Like if he said that Title VII, I'm interpreting it this way, then that's an issue for the courts because that's a law that already exists. But you can't say, well, Congress isn't going to pass it, so I'm going to write my own laws. Like that's not how it works, or it's not how it should work. It works too often that way with too many presidents, but that's not how it should work.
I did also, I guess, want to make sure people are aware of this, that ENDA or acts very similar to ENDA actually stretch back to the 70s, but ENDA in its current form has come before every Congress since 2007, and in a form without the gender identity protections has gone through every Congress except one between 1994 and 2007, then with the gender identity qualifications since 2007. So this isn't brand new, which I think is part of why these organizations were saying, look, when you added this, we originally thought that wasn't going to be all that troubling, but in light of these new rulings, we'll go back to the original wording that we've been fighting for the last 20 years.
Right. And, I think and I support them doing whatever they feel is best they need to do to get this legislation passed, because, I mean, it's far past time that we have some sort of equality in the workplace. That you can't discriminate. It's crazy here in 2014 that we can still discriminate against people on the job site because they're gay. That's insanity.